Hello, I'm State Senator John Kavanaugh, also Dr. John Kavanaugh, your instructor in this course, PAF 494-591, Public Policy, focusing on state legislatures. And this is Lesson 5, Bill Drafting. Now, three terms you should be aware of. There's the spirit of a law, the letter of a law, and the judicial interpretation of the law. The spirit of a law is what those who wrote it want it to say, do, express, or whatever. The letter of a law is the way the bill drafters put that in writing. And the judicial interpretation of the law is how a judge interpreted what it means or what it does in the event that the meaning or enactment or execution of a law is questioned. So now ideally, all three would align. In a perfect world, the letter of the law would capture the true spirit of the law and would be unambiguous so that there would be nobody challenging it in court as to what it means. So ideally, spirit, letter, and judicial interpretation would be the same, but it isn't always that way. And good bill drafting can get it as close to that as possible. Now, ideally, laws would be written in plain language and be straightforward. Everyone hears about legalese, confusion, right? Ideally, you wouldn't have to have legalese. You would, and long, rambling text. Ideally, laws would be plain language, straightforward. But that's not always possible. Uncomplicated language is not always suitable for very complicated issues, especially when lawyers will be paid to pick the language apart and interpret it in a way that favors their client. So we often have to have complicated languages in law, which means that laws become very long. But ideally, laws would not be excessively long, but they very often are. So unlike contracts, laws cannot cover every contingency. So even though to be perfect, they would have to be convoluted, long legalese, in reality, they can't be written that way. They have to be written shorter and hopefully with language that isn't too full of legalese. Because laws aren't contracts. Contracts are a lot different. Contracts are drawn up by lawyers for clients, and they have plenty of time to research what the client wants to say, what the client needs protection from, and they can write all they want to protect their client in the contract. If you've ever agreed to the terms of downloading an app, right, it goes on for pages and pages and pages. I mean, it's so convoluted and long, most people never read it. They just click, I agree, and move forward. But those are contracts that cover every contingency usually. Laws can't be like that. Laws have to be much shorter, and they can't have too much legalese because they're meant for people, not people with law degrees to read. So let's move forward. Now, there are other issues in law drafting. Poor communication between the legislator and the law drafter regarding the purpose of the law is a problem. That will result in the written law not being aligned with the spirit of the law. There could be poor drafting by an outside entity. Legislative councils don't always write the laws that legislators pass. Sometimes legislators get the laws from special interest groups, from government agencies. Sometimes they copy a law from a different state because they liked it. So outside entities might have drafted the law improperly, because when it goes to the legislative council in the state where it's being run, in a case where the language is given to our drafters, they will usually simply put it into the form and style of our laws so it aligns with those. And they may point out serious problems that they see, but they're generally concerned with form, style, and one more thing. They want to make sure that the new law doesn't contradict and properly aligns with existing law. Sometimes legislators put poor language into a bill to get votes. And not just poor concepts or poor clauses, but sometimes the wording is made vague or ambiguous for a political reason to get a vote. And poorly drafted laws can create unintended consequences. and they can be really bad consequences. We had a case, I don't know, 10, 15 years ago where, more than that, I wasn't in the legislature, it must have been about 25 years ago, where they drafted a law that gave a rebate, tax money, to people who converted new cars they were buying into multi-fuel vehicles. It was supposed to cost $60 million. It went totally ballistic. When the amount hit $300 million, the legislature pulled the plug and canceled contracts and walked away $300 million poor. But that was a poorly written law. All right, so let's look at when is a law poorly written, drafted, same thing. Well, if it contains incorrect, ambiguous, or vague definitions, that's a problem. If it uses improper grammar, another problem. If the law is not aligned with legislative intent, big problem. Or if the law creates absurd outcomes. These are big problems. So let's talk about the first problem, which is poor definitions. Now, generally, we like to use the ordinary meanings of words when we write laws. And you can find the ordinary meaning of words in dictionaries. But dictionaries can also contain many multiple definitions. So you very often have to clarify the definition in the statute. Like if you go to the dictionary for the definition of vehicle, let's say you wanted to pass some law regarding traffic, people riding vehicles in the park was the example in the book. Well, you got different definitions. A means of carrying or transporting something is one definition. A piece of mechanized equipment is another. An agent of transmission, like a carrier. A medium through which something is expressed, achieved, or displayed. An inert medium, such as syrup, which a medically active ingredient is administered. So obviously, not all of these definitions are what we want in the law. And even some of them are too general. A means of carrying or transporting something. That's a wheelbarrow or a baby carriage, and I don't think we'd be regulating those on our roads. In addition, word definition can sometimes differ within the law itself and therefore needs clarification in different sections. Let me give you an example. Most penal codes in the very first part of the code will have a general definition section, and that defines general terms like person, corporation, injury, what have you. Right? However, there are sometimes in individual sections of a law where the definition is slightly different, and they will redefine the law for the purposes of that section within that section and not in the general definition section. So you always have to be alert to the definition that you're dealing with in law. What do you do? What do courts do when words are ambiguous, like the word vehicle? Well, judges use a principle called e justem generis, which is a Latin term. And that principle says that the general words that follow certain specific words are limited by the context of those words. So general words that follow specific words, the generalness of those words in the end are limited by the context of the words before them. So a definition of vehicle that said, they shall include an automobile, truck, wagon, motorcycle, or any other self-propelled vehicle not designed for running on rails, would not incorporate airplanes under the term other self-propelled vehicle, because all of these specific examples before it were land-based and planes fly in the air. Judges will use this principle. The second problem is improper grammar. Word placement and punctuation matter, especially in law. The legal rules of construction are called the grammar canons. And one of them is the rule of the last antecedent. And it says that the modifier at the end of multiple nouns or pronouns only modifies the last one unless a comma sets off the last one. Let me repeat that. The modifier at the end of multiple nouns or pronouns only modifies the last one unless a comma sets off the last one. So let's take an example. The sentence, this basketball team has a 7-foot center, a huge power forward, and 2 large guards who do spectacular dunks. Note, in this sentence, there could be a comma or no comma between the word guards and who do spectacular dunks. And if there is no comma separating guards and who do spectacular dunks, then the sentence means that the 2 large guards do spectacular dunks and not the 7-foot center and the huge power forward. But if you put a comma which separates who do spectacular dunks from the last nouns, 2 large guards, then that comma means that who do spectacular dunks will apply to all 3. The comma severs that description from the guards and means it applies to everybody. And of course, that may or may not be, that may be only one of the clues that a judge would use to determine the interpretation. If I was a judge in a case like this, and you didn't have the comma, I would perhaps suspect that even though there is no comma there, that the person who wrote this meant to apply who do spectacular dunks, not just to the guards, but to the 7-foot center and the huge power forward. Because if you know basketball, a 7-foot center and a huge power forward clearly can do spectacular dunks, probably dunks more spectacular than the large guards. So again, here we see the rule of the last antecedent, which tells us how the comma affects it, but it could be overridden by other factors. Moving on. Misplaced modifiers. A person commits, so let's look at a law. A person commits interfering with an arrest when they, with intent, forcibly assault, comma, resist, comma, or impede a police officer making an arrest. Now let's look at that sentence, right? Well, the modifier here is forcibly. So the question is, what does forcibly modify? Does forcibly only modify assault, or does forcibly also modify resist arrest or impede a police officer making an arrest? Well, that's important. And I'll say the reason why it's important is this. If forcibly only modifies the word assault, then a person who resists arrest without using force, goes limp, would be guilty of this crime of resisting an arrest, right? And if forcibly only modifies assault and doesn't modify impede, then somebody who non-forcibly impedes somebody would also be guilty of the crime. However, if forcibly modifies assault and forcibly modifies resisting arrest or forcibly impeding arrest, if forcibly modifies all 3, then those who resist or impede a police officer making an arrest without using force are not guilty of the offense. So, a person commits interfering with an arrest when they intentionally forcibly assault an officer making an arrest, resist the arrest of an officer making an arrest, or impedes an officer making an arrest. That is the way you would interpret this statute if forcibly only modifies the word assault. Other grammatical or semantic quirks. Shall in legal jargon means to impose a duty to act, while may grants discretion to act, and may not is a non-discretionary prohibition. So, and those are important because you'll see in law it'll say may, it'll say shall or may. When a law says shall, you have to do it. When a law says may, you may or may not. Strangely, may not, though, means that you can't do it. All right, the canons also prefer the singular form to the plural, disdain legalese, slang, pronouns, and abbreviations, have a very limited use of acronyms. They prefer the present tense to the active voice, and given the choice between these words, they prefer fewer over less, consecutive over successive, continual over continuous, assure versus insure versus ensure, farther versus further, funds versus monies, that versus which, and person versus individual, to name just a few. Now, these are very nitpicky, but these are the type of form and style issues that a law drafter will stick to as they draft legislation. Let's move on. All right, this is problem 3. I'm going to take a break now, and I'm going to end part 1 of lesson 5, and we'll pick up problem 3, not aligned with legislative purpose, in part 2.